Number 67, John W. Terry et al., Petitioners versus Ohio.
So this is everything you need to know about Terry versus Ohio.
I'm saying that the point that you lay your hands on the citizen and you begin to exercise dominion over that citizen on the streets by spinning him around, in order for you to do this, that you must have the probable cause that is required to place a person under arrest, because this person is substantially under your custody, your dominion.
Then you mean he can't frisk for a weapon without probable cause to arrest? Is that what you're saying?
Yes.
Pay very close attention. This next part is where we all lose our liberty, where the Fourth Amendment is washed away. Pay very close attention.
Didn't your own court say they still did not have probable cause for arrest? As of this point, we're now at.
The trial court indicated that at this point that there was not probable cause for arrest. The appellate court did indicate that there was probable cause for arrest after the frisk took place.
No, I mean, we haven't frisked him yet.
That is correct.
So he didn't have probable cause to arrest when he approached.
I would agree with this.
And he didn't get probable cause till he put his hand on the butt of the gun.
He didn't get probable cause to arrest
him until he put his hand on the butt of the gun in his inside coat pocket.
No, sir.
Is that right?
No, sir.
Well, when did he get probable cause for arrest?
He received probable cause for arrest when he turned Terry around and ran his hands over the outside of his clothing and feeling a gun in the upper left breast pocket and indicating emphatically at that time that what I felt was a gun, a weapon.
Well, he didn't have it, as counsel for petitioner says, he didn't have it when he laid hands on him and turned him around.
I would agree with, he did not have probable cause to arrest.
Right.
I would agree that he would have probable cause to frisk or to lay hands on him at this point.
Why?
Because of the nature of the circumstances and protection of his own life.
The lawyer is telling the Supreme Court justice the constitutionality of probable cause. If the white cop is afraid for his life, that matters more than your civil liberties.
Because of the nature of the circumstances and protection of his own life. I find no problem with this particularly because I do not ask for a different standard of probable cause as it may relate to the right to lawfully arrest a person. I think that the quantum of evidence that is basic and essential under the circumstances to establish probable cause for the officer to arrest, for to stop a person and to ask him questions may be somewhat lesser in degree, but by the same token it is probable cause under any circumstances.
That's incredible. That's incredible. He's saying here that if a cop looks at you and he thinks that you could be armed, that's probable cause. That's basic. If the officer feels as though his safety is in jeopardy because he thinks that maybe you might have a weapon, then it's always probable cause. It's always probable cause. And what's the results of making every officer have probable cause in their mind at all times? It's that. That is the result of probable cause right there. You're looking at it. Here's the result of probable cause of an officer being in fear for his life at all times of you. And he says it. Louis Stokes, he nails it. That is exactly our culture today. That's exactly our culture. You're always a suspect.
The same circumstances are indicated.
What do you understand probable cause to mean that a thing may happen?
The Supreme Court personnel are debating back and forth what probable cause is. Probable cause is when you have broken the law supported by oath or affirmation, that you've created a victim. That's what probable cause is. There's no need to kick around what it is. You've broken the law and created a victim supported by oath or affirmation.
And to, if I may put it in my own language, I am saying that there was probable cause for the officer to interfere with their freedom of action at this point.
Well, that's what I say.
Such interference with their freedom of action is not in a significant way at this time.
Well, that's what I understood to be your argument from the use of probable cause. Then what you're really doing is saying you don't have to change the labels Still probable cause, and it's still an arrest, but an arrest for the purpose merely of asking a question, who are you and why are you here, is a different thing from an arrest for the purpose of taking the station house to book them for a crime, you know?
Do you hear what they're doing? They're trying to normalize that police should be able to run up and grab you if they're suspicious of you.
Under Ohio law, I could not agree with this concept because under Ohio law, the definition of arrest is by statute.
By what?
Statute. And it contemplates
Well, forgetting Ohio law for a moment, how about for the purposes of the Fourth Amendment?
for the Fourth Amendment, it would be a reasonable action on the part of this officer, and if...
But I thought you agreed with Justice Black before that really reasonable action and probable cause are pretty much synonymous terms.
The Supreme Court changed the meaning of words to create the word detained because seized is already in the Constitution. It means arrested.
There was a touching...
What's the difference in seizure and arrest? You may seize him because you seize something tangible. But that's not what you're talking about in the seizure of the Fourth Amendment, I thought. I thought it was an arrest, evidence of arrest.
It is arrest that I understand that we are discussing in this matter.
Well, an officer could very easily turn a man around without arresting him.
I agree with this, and this is the position that
It might not
I
be
take.
easy, depending on his size.
That he could very easily turn the man around, and some may term that as a seizure.
KKK member Hugo Black is trying to argue that seizing you is not arresting you if it's not for the intent to take you to the dungeon. You're really not seized unless you're taken to the dungeon. He's trying to say, well, that's not what it means constitutionally. He's a Supreme Court justice supposedly standing up for our civil liberties.
But I would not term it as a seizure of the person himself unless he has the intention of taking that person into custody, even though he may lay hands on him at that particular time. The first seizure of the person was at the time that he ordered them into the store.
You mean when he took Terry and swung him around, there was no seizure of the person?
I think there was a temporary detaining or interference with his
Well, he had
person.
his hands on him when he switched them around. Surely there was no seizure of the person.
But here again, we're dealing in simply semantic words.
No, I'm asking, that word's in the Fourth Amendment, isn't it?
Agreed that it is, certainly.
Play that back again. Listen to what they're doing. They're changing the definition of detained. Because when detained means seized, he says, isn't that word in the Fourth Amendment? Against unreasonable searches and seizures? But now detained doesn't mean seized in what world? At the Supreme Court. At the Supreme Court. Because if you've been seized, then you've been arrested. And you can't be arrested on reasonable suspicion. You have to be arrested on probable cause.
That the defendants were conducting themselves suspiciously and some interrogation should be made of their action. 5, there was reasonable cause in this case for the officer to approach these individuals and pat them down. Here is a decided attempt on the part of the trial judge to equate and balance the rights of the individual with the rights of the public and the safety that is involved herein as it pertains to the officer in this particular case.
The Terry laws that we live under today were not written by a legislator. Congressperson writes a bill that's a law, and then the president signs the law into effect. This is our constitutional process. The Terry laws were not signed into effect by the president of the United States. That's not what happened. The Terry laws that we are forced to live under today were written by a Cuyahoga County trials judge named Bernard Friedman.
The trial judge made these remarks. A police officer cannot, as far as this court is concerned, and will not be permitted to stop and frisk an individual simply because he has a suspicion, a mere suspicion, unless there are reasonable circumstances justifying the frisk. When the circumstances justify, and there is reasonable suspicion, and for his own personal protection, he may frisk to determine if there are weapons for his personal safety. The officer assigned in the area which he had been placed, doing the job he had been doing, and had reasonable cause to believe and to suspect.
Probable cause is not probable cause to see or probable cause to believe. That's not possible. How can probable cause to see be supported by oath or affirmation? The cop swears, he promises that he believes he was in danger. So your civil liberties have to go.
that the defendants were conducting themselves suspiciously and some interrogation should be made of their action, there was reasonable cause in this case for the officer to approach these individuals and pat them down. Here is a decided attempt on the part of the trial judge to equate and balance the rights of the individual with the rights of the public and the safety that is involved herein as it pertains to the officer in this particular case.
This next part is where the Supreme Court personnel will inject that this entire thing is about officer safety.
And here there is no suggestion, is there, that the policeman had any basis for fear as to his own safety? Am I right that there's nothing in the record that indicates
There's
that?
nothing in the record whatsoever.
I don't understand your answer to Justice Fortas when you said there's nothing in the record to indicate that the policeman didn't have concern for his own personal safety, because I thought he said that based on his intuition, he thought these people were casing a place in order to rob it. Isn't that what he said?
This is what he said.
Well, presumably then they would be armed, and the minute he walked up and talked to them, he would quite reasonably be concerned for his own personal safety, I should think.
Well, police officers are very often in a position where they might not be able to make an actual arrest, but they are in a position of great danger. And where they are in a position of great danger, are they in a position to protect themselves from violence by looking into the situation to see if anyone is armed to do the violence?
Yes, Mr. Chief Justice, he certainly has a right of self-defense, and he has a right to protect himself.
Just atrocious. Listen to Louis Stokes.
Whether with or without reasonable cause, he thought or suspected that these were armed robbers about ready to hold up a place. And I suppose if you walk up to such people and begin asking them embarrassing questions, you might have some little concern for your safety if you bona fide believe that they have weapons on them. Now, that much is in the record, isn't it?
Yes, sir.
No, is that so? Excuse me, but is that so? Does the record show that he thought these men were armed before he put his hands on them?
Yes, he says, after he says that he thought they might be casing a place, and I felt that they might have guns. He did.
He said he testified to that effect.
Yes, he did.
Don't you think he'd be justified in the first instance in confirming whether or not they did have weapons before he went on further to interrogate? On the premise that it was reasonable for him to think that they had weapons.
Take a situation of this kind where a police officer sees someone acting very peculiar. Might not be in connection with any information he has about any crime. Maybe the person is abnormal mentally. Maybe he thinks he's insane, and he wants to talk to him. But the man shows indications of he thinks of violence, and he wants to be sure that he won't be attacked when he goes to talk to him. And he goes up to speak to him, and also ascertains whether he has any weapon on him. Did you think he had a right to do that? As a matter of probable cause that he might be injured himself if he doesn't take precautions.
The average police officer would do this under these circumstances. If he felt himself to be in any type of danger, that he would conduct a search for the purpose of protecting his own life in a possibly dangerous situation.
You don't tell the Supreme Court that you're arguing that police shouldn't have the right to run up and grab you and then say, well, this is what a police officer would probably do anyway.
Mr. Justice, I'm sorry if I'm giving you the impression that the police officer cannot ask him a question.
I said can ask him a question, but cannot get an answer and do nothing about it.
He can arrest him if he chooses.
He can arrest him. But suppose he doesn't choose to arrest him.
Then
Suppose he wants to do something short.
And I don't think he has that right.
If you read a little biography on Hugo Black, he said that he left the KKK. This is him in 1968.